Welcome to Solving Citizen Legal Encounters. All right, today we have a pro se defendant who wants to go against his creditors because he owes money and he wants to dispute it. Now, the way he disputes it and the way he brings his defense has a twist to it. So let's go in and check out the case and see how this is going to go. Let's go.
Tyrone Dancer. Mr. Dancer, if you could unmute for me again. Are you there?
Yes, I'm here, Your Honor.
Okay. Mr. Jamal?
Yeah, so there's been no resolution on this matter, so we'll just be proceeding with our motions today. And I believe there's a motion for summary for plaintiff, as well as a motion to dismiss the counterclaim, as well as defendant's motion to dismiss plaintiff's claim.
Start out with, I guess, probably the easiest one is Mr. Dancer's case to dismiss. Motion to dismiss. Let's start out there, I guess. Mr. Dancer, this is your motion to ask me to dismiss this matter.
Yes, I ask you to dismiss this matter based on the ownership of debt. The plaintiff has not produced the original contract or agreement bearing my signature with Credit One Bank. And without this, they cannot establish privity or enforceability of the debt. Also, there's an issue of chain of custody. The plaintiff references a chain of assignments relying on a file named Credit One Fresh Resurgent 022023. However, this reference electronic file is not included in their evidence submission and thus inadmissible hearsay. Further, many of the assignments merely incorporate Exhibit A by reference without producing the data itself, creating an evidentiary gap. And the plaintiff has failed to provide a complete chain of assignment in a matter that a non-lawyer defendant could meaningfully inspect and challenge. The absence of the referenced Credit One Fresh Resurgent 022023 file denies me the opportunity to review the specific details of the alleged obligation. This omission infringes upon my right to a fair opportunity to confront and dispute the evidence under the Due Process Clause of the 14th Amendment.
Okay. Mr. Jamal, do you want to give me a response to that one first before we?
Sure, please. So we've filed a response. With our response, we've included the detailed account documentation, which includes statements from, I believe, zero balance to the charge-off amount supporting that the account existed, that defendant used the account, the balance due and owing. There is no requirement or need for a signed contract, given the fact that this is a credit card. Defendant's use of the credit card constitutes his agreement to the terms and repayment of that account. We've also included the cardholder agreement, just verifying terms of the account. And finally, we have included the chain of assignment. This is the actual chain of title documentation, copies thereof, which also includes the Exhibit A that is referenced, the receivable file that defendant referenced, Credit One Fresh Resurgent 022023, and the portion of that that is relevant to this case, which indicates that defendant's account at issue was transferred from original creditor Credit One to my client, LVNV Funding. So we would ask that the court deny the defendant's motion to dismiss.
Okay. Mr. Dancer, you get last stab at it there for your motion. Anything else?
Yes. Exhibit A, the file reference list of Credit One bank accounts, which includes my name, a redacted social security number, and the last four digits of the alleged count 2898. This spreadsheet is referenced by plaintiff but lacks authentication, signature, or chain of custody verification. This basically boils down to just hearsay because there's no chain of custody for these documents, nor is it clear. Hold on, let me pull up 1 second, please. Plaintiff has submitted fragmented statements that don't demonstrate a full account history, chain of ownership, or verifiable balance. The statements provided, like the one from July 2022 showing up a $555.98 balance and another from January 2023 reflecting a $996.99 balance lack continuity, clarity on how charges accrued, or proper itemization of fees, interest, or payment. These inconsistencies suggest error or lack of proper documentation needed to enforce a debt under FDCPA standards and Michigan contract law. Additionally, all chain of assignment documents referenced and electronic file titled Credit 1 Fresh Resurgent 022023, supposedly containing the account schedule. However, this reference file does not, I'm sorry, that was an incomplete statement. But they are incomplete and lack supporting detail. No signed contract, no full transaction history, and no proof that this debt was correctly assigned through every level from Credit 1 Bank to LVNV. These statements also show differing balances without explaining how they were calculated. Apologies.
Normally, if you owe a bank money and you get behind on payments, they will send you a lot of notices to let you know that you're behind so that maybe you can get caught up. But after a certain point, they're going to sell it to third party, and they always notify the person when that's about to happen.
First, argument with regard to not being able to understand the documents supplied without having a legal degree or a law degree. That portion is inconsequential for today. Mr. Dancel, you've got every right to have an attorney here. You haven't got an attorney here. The documents are
I can't afford
just
one.
what they, hold on, it's my turn. It's my turn to give my answer. You have a right to have an attorney here. You had a right to hire an attorney, have an attorney present today. All of the documents are, whether they're in legalese or not in legalese, you run a risk when you're not represented by an attorney or don't have your own law degree. And even if you had your own law degree, you still run a risk when you're trying to defend things on your own. That's my first comment. Second comment, I have had a chance to review the pleadings in this matter. This pleading is based on allegations that this is a credit card debt. Those laws apply to this matter. There was attached actually to the complaint as well a number of documents showing Tyrone Dantzler Jr. as being the owner of that credit card debt. There is a number of documents showing an address that is consistent with the billings for that document, that credit card debt. There's enough for to proceed on those bases alone. The motion to dismiss is denied. And with that, we're back to motion for summary disposition, and I guess let's go with the summary disposition. I guess that's probably the easiest.
Okay.
Mr. Jamal.
Yes, so the summary disposition, primarily we addressed on our pleadings. We've kind of gone through all the documentation which is provided in our response to defendant's motion to dismiss. That similar documentation is provided with our motion for summary, including detailed account statements supporting usage, interest, fees, accrual, as well as the charge-off balance and the balance we're seeking today, as well as the chain of assignment. And just one brief thing, as it relates to admissibility for any of this documentation, there is Michigan case law supporting the fact and the ruling that at a motion and motion for summary stage, it is not necessary to lay the foundation as long as the documentation would be admissible at a trial. Foundation is not necessary at a motion. So we would request that the motion for summary be granted for the amount of damages sought, $986.99 plus costs.
Okay, and Mr. Dancer, first of all, I'm looking for a response to the motion. Did you file a response to that motion for summary disposition?
For summary disposition, I don't
Make sure.
believe specifically for the summary disposition. I filed a motion to dismiss, due process violation, demand for discovery, and a FDCPA violation.
But no response to the motion?
And what exactly, which motion is this?
Summary disposition based on
Summary
MCR 2.116C9 and C10.
I don't believe I have that. I have everything in our possession.
I have a proof of, I've got a notice of hearing that was sent out to,
Motion for summary disposition. Okay, I do have that. I did not.
okay,
No complaint. This motion is brought under the defense. Yes, I didn't follow an answer to this summary disposition. No.
okay, that's gonna be a problem as well. I'm ready to proceed with that as well. I have had a chance, actually, Mr. Jamal, before I review the entire documents, anything else with regard to no response, that type of thing? You want to give me?
No, I don't, no further response to that.
Okay. This is a motion brought pursuant to MCR 2.116C9 and C10. C9 being based upon the pleadings in this matter. C10 motion based upon all the pleadings and attached documents for summary disposition motion. And Mr. Jamal is correct that the attached documents are found in a form and consistency that would at this point find to be admissible evidence for trial purposes. I did get a chance to review all the attached documents, the complaint itself, as well as responses. Actually, I'm going to consider answer to the complaint, but no response to the motion for summary disposition. This court is bound to review all of these documentations, find based upon all these documents that have been submitted. There has also been an assignment of receivables, bill of sales that was also attached within those documents. I've got a number of documents that are copies of billing statements that were sent to Tyrone Dancer Jr., all consistent with the billings in general. All of them are consistent with an address of 1906 Woodsley Drive, apartment 10, Tyrone Dantzler. Figures are all consistent with amounts owed. There were some payments made on this account as well. And there's, again, as I mentioned, assignment of this assignment of receivables for this debt that was owed to now LVNV Funding LLC. Do you find there's no genuine issue of material fact based upon all that documentation? For Mr. Dantzler's, just for his understanding, Mr. Dantzler, you can't just lie on your laurels when I have a summary disposition motion filing. I'm duty bound to look at all documentations provided. There's been no contesting any of those documents that have been provided. Again, therefore, no genuine issue of material fact based upon MCR 2.116 10 and C9 based upon the pleadings. Therefore, motion for summary disposition is granted on both counts, which leads me to a counterclaim, I guess. Got a counterclaim in there.
That's correct. Defendant filed a counterclaim under the FTCPA, citing the fact that, or alleging the fact that we have not provided, I believe, validation and or verification as required by the FTCPA. However, he does not indicate that he even demanded such verification to be provided. We don't have evidence of any sort of dispute letter or request for validation received by our office. At this stage, there's a proper counterclaim under the FTCPA has not even been cited, and no documentation supporting that request was made. Therefore, we believe the counterclaim should fail and should be dismissed, as there is no claim stated at this point.
The Fair Debt Collection Practices Act, FDCPA, is a federal law that regulates how third-party debt collectors can interact with consumers when trying to collect debts. It aims to protect consumers from abusive, deceptive, and unfair debt collection practices.
Mr. Dancer, with regard to
Yeah.
your counterclaim here. He's suggesting this, it should be dismissed. Go ahead and tell me what you want.
Respectfully, Your Honor, I brought this counterclaim against the plaintiff under the Fair Debt Collection Practice Act 15 U.S.C. Section 1692 for attempting to collect the debt without providing validation upon request and failing to give proper notice of debt assignment. Defendant, I seek statutory damages, court costs, and other relief of court deems just. The reason I brought this case, hold on, let me pull this up. I'm sorry, I'm so unorganized, and as you say, I'm not legally adept.
Yeah,
And
I
I'm-
understand.
And I'm learning as I go right now, and this is very daunting. And it's just me trying to stave off what I feel is robbery. It's not me trying to attempt to evade responsibility.
Well, I appreciate that.
It's my goal in all of this is only to stand under the law as it's written, as I understand it.
For those of you who watch these videos where people don't pay the creditor, credit card company, bank, when LVNV gets involved, normally it's because they didn't pay the original creditor. So taking responsibility, I don't know. I don't know the circumstances. I'm just making a comment.
And if I'm misunderstanding it, then that's due to my lack of education.
Well,
as far as
how did you do your research on this thing?
I
Use
actually
artificial
used AI.
intelligence? Did you use AI
Yes.
somehow?
Yes, I did use AI.
That's what it looks like. Sir, you got to be careful when you use that stuff. If you don't know what you're doing. It just leads you down these rabbit holes that just won't make much sense. And I'm not. Well, I am pointing my finger at you, I guess. You just got to be careful because everybody tries to do that thing. Okay, gosh, this sounds great. And it's really not the path that legally is making sense on some cases. You know what I mean? So you really do run a risk when you just kind of pull things up like that. You just do.
All new here at 10 o'clock, a Utah lawyer is facing consequences for filing a brief using AI and referencing a court case that doesn't exist. That's according to the Utah Court of Appeals. Now, documents say attorney Richard Bednar's brief used false citations created by ChatGPT. Bednar acknowledged the errors and says one of the law clerks at their firm is the one who wrote the brief. The Court of Appeals says this is the first time a court filing has been created with AI that they know of here in Utah. Bednar is set to help pay back legal fees and donate $1,000 to a Utah legal nonprofit.
But go ahead and whatever else you got. I guess my question is, Mr. Jamal raised an issue with regard to sending some type of a dispute letter or something, asking for validation on the account. Did you do that? And just be upfront with me.
Yes, I did file a motion. When I filed my first motion to dismiss, I demanded for discovery in this matter. And when they first responded to that, I didn't receive anything of the type that I got later on. There was a second letter that came with the exhibits in it. So when I first started doing filing my paperwork, I didn't have all of the information that I later received, which would be the resurgent 022023 file, which according to my understanding, as far as what the information that I received on that is that there has to be a chain of custody, to show that this isn't just something that they printed from a bulk file, which is the issue that I'm having with it personally. It doesn't seem to be validated. And you should have, I would expect that there is a witness from the original creditor to validate these amounts. So this is the issue that I was having. And with the counterclaim of the FDCPA violation, there wasn't anything at the time when I filed that. I didn't have all of this. And even when I did receive it, it still feels insufficient because I've never seen any of this before. Everything that I'm receiving is brand new, and I didn't even know that this was a thing until I got the summons to come to court. So I had no clue that there was a debt lingering over my head and that there was a case coming against me until I received the summons.
Here's the question. Do you think he was previously notified, or he's telling the truth and he had no clue that this debt was coming to him?
So let me just ask you, and again, I'm not trying to be tough on you, but I gotta follow, court rules. This is a civil case. Did you file any kind of motion with me for discovery? Let's just start out there.
There was a demand for discovery in the
No,
original
for
motion.
me, I don't think I've got any motion for discovery where I had a chance to have both the argue as far as getting documentation, everything through me, ordering it through the court. At least I don't have anything on record that I see.
I have
Mr.
it
Jamal, was
stamped
that-
by the court. I have it stamped by the court on May 9th, 2025. Defendant
was May-
Tyrone Dancer hereby submits the following documents in response to the complaint filed by plaintiff.
Okay, I gotta have a motion in proper form though. Was that a motion for me that was not? You
Yeah,
didn't have a
Judge.
clearance-
We had the same
No,
note. We had an indication that we did receive his demand for discovery, but we never received a discovery order from the court. And therefore we've kind of held that in advance and figured the responses with the motion and everything else provided the documentation he needed.
Yeah, I got it.
Okay, so-
Mr. Dancer, I'm not trying to be, I really not, honestly, but I gotta keep control of what I end up with, because then I end up down some darn rabbit
Yeah,
hole.
this is a learning process for me right now.
Yeah,
I'm learning.
so, okay, well, hopefully you don't have to learn anymore after this. So-
What the judgment is, I'm going to come back.
I'm sorry?
Over yet, because whatever the judgment is, I will be back.
Now, either he feels he's going to lose this case or he has another case pending.
Okay. We, there was no order, I didn't have an order for discovery on this matter either, and
I apologize.
no, that's okay. That's just the way it is. Given everything I've heard though, as far as argument with the counterclaim, the counterclaim's dismissed based upon the motion for summary disposition, all those documentations as well, and everything I have in the file and the argument I heard today with the with respect to the counterclaim at this point. There's no dispute letter in file. There's no demand for validation for records in the file. There's no order for discovery. For all those reasons, the counterclaim is dismissed. Okay.
Your Honor, do you want me to submit, I guess, orders, dismiss and counter?
Yeah,
deny
could you
motion
do-
dismiss, and you should have the proposed judgment for the motion for summary, but I could submit orders on the other two.
I do have the judgment for summary disposition. Let's just make sure I do that. Yeah, I do have a order for summary disposition judgment for total 1,144.36. I do have that, which comports with what I ordered. I'll sign that order. And then, Mr. Jamal, if you could for me, just on the motion to dismiss, denied, defendant's motion to dismiss, and then the counterclaim is dismissed. And I think that covers it.
I believe so.
Okay. All right, we'll do it that way. Mr. Dancer, it was a pleasure. You did a good job. You did, but boy, you just gotta be, I'm gonna tell you the same thing. You're running a big old risk doing this yourself, okay?
Yes, I understand.
Okay.
So what are my next,
Well, I
what
can't
is my,
give you, I don't mean to cut you off, but that's gonna be the next question I get asked all the time. I can't give you legal advice. So I just gotta go through with the orders, and if there's something that you're, I don't know, demanding of me or appealing for me, those kind of things, that's up to you, okay? I just can't give you advice. Because if it comes back to me, Mr. Jamal's going to say, well, what the heck, what are you doing? You're giving advice from the bench there, and I can't do it. Okay?
Okay,
All right. But good luck to you anyways.
Thank you all.
okay.
All right. You're welcome.
Bye now.
Bye now.
And as I always say in these cases, pro se is not the way. Now, I'm all for AI and the technology and all of the good stuff. But if you're going to use AI, make sure you double check what the AI tells you. Because ChatGPT, everybody's using it. But if you're using it for legal, you need to go back and check. If you're using it really for anything that you don't know off the top of your head that you're trying to verify, always double check the AI, because AI make mistakes. They're not perfect. They're good. They're quick. They can get you things pretty fast. But sometimes all of the information may not be accurate. See you on the next video.